Hi, this is Kirkpatrick again. Today I want to talk about arbitration of your workers' compensation case. Now, this applies whether you've got another lawyer, whether you're pursuing your case on your own, whatever. A lot of times my clients question me about how their case gets resolved. Well, there's two ways. One is by settlement, and that's where everybody agrees to the amount of money or percent of loss of use as it may be. But the other way is by arbitration. Arbitration in a workers' compensation setting is it's a trial, but instead of being at the courthouse and in front of a judge or jury, these arbitration hearings are held at different locations throughout the state, and the arbitrator is like a judge. She hears the evidence and makes the decision. But here's what I want to explain to you, and that's how this process now works. It's different than what it used to be after COVID. So now if your case is on a workers' compensation docket and you set it for hearing as a hearing on all issues, your case will appear on, let's say, for example, the Collinsville docket on a particular day. Your lawyer, or you, if you're representing yourself, will attend a docket call, not in person anymore, but on Zoom, by teleconference, on the computer, or by telephone, whichever the case may be. At that point, your lawyer announces that your case will be set for hearing and that they need a pretrial date and hopefully a trial date. So what happens is, on that particular day, if you're pro se, you call in or get on the docket call on the computer. You can get the information from the Illinois Workers' Compensation Commission website. And when your case is announced, you ask the arbitrator for a pretrial date. Every case now has to have a pretrial date so that the arbitrator can talk about the issues, but I'll discuss that in a minute. Once your case is set for arbitration, you go to the docket, tell the arbitrator you want a pretrial date. He will assign a pretrial date the following week. Now, at this point, you don't have to be present if you have a lawyer, and then you don't have to be present at the pretrial if you have a lawyer. At the pretrial date, then, the arbitrators will give us a trial date. The trial date, unfortunately, isn't until the following month, and it may be 3 weeks down the road or it may be 4 weeks down the road. But then the arbitrator puts us on a list of cases that will actually go to arbitration if they're not resolved. I'll talk about arbitration in a moment, but first I want to talk about what happens at a pretrial. A pretrial conference is when myself, or your lawyer, as the case may be, will get together in a telephone conference with the arbitrator, and they will discuss the issues in the case. And the issues may be whether you had an accident at work, whether it's a compensable claim, or it may be as simple as, how much of a percentage of loss of use you're entitled to based on the injury you have and the continued complaints and problems. The arbitrator then typically makes a recommendation on what she thinks the outcome would be if she were to hear all of the evidence. The pretrial conferences are generally pretty successful. Generally, the issues get resolved in part because the arbitrator who's hearing the pretrial is the same one who would be hearing the evidence. So if the lawyers have given correct summaries of the evidence, you can pretty much bet that arbitrator is going to be pretty close after arbitration to what she said in a pretrial. But now let's suppose that the pretrial doesn't work, the parties still can't agree, and they have to go to arbitration. All of my clients seem to get nervous when I mention the word arbitration, but this is really not a big deal. At arbitration, by the time we get to arbitration, I will have your medical records prepared and marked as exhibits. If we've taken the testimony of your doctors to present at arbitration, I will have that. In other words, we will have all of our exhibits ready, and then what happens is I will call you to testify, and you will testify about everything from what happened to you, what doctors you saw, and then primarily what kind of treatment you had, but then most importantly is what kind of ongoing problems you continue to have, because that's what the arbitrator, in part, what the arbitrator uses to base their decision. It's a very simple process. There's no jury, like I said, there's no judge. It is nothing for a client to be worried about. Most people testify much better than what they ever expected. So, in summary, whether you're represented or not, it's the same process. You file your petition for hearing, you show up on the docket day by teleconference, the arbitrator gives you a pretrial date, and then if your case is not resolved and you're fortunate enough to make the trial list, then you will go to arbitration the following month. If you have any questions on this or need representation on your workers' compensation case, give me a call.